Hello, I'm David Gibbons. Well, it's all over. After countless legal battles over many years at courts at every level, the US Supreme Court has finally ruled in favour of cartridge remanufacturer Impression Products in a case brought on them by OEM Lexmark International. The case has been over two patent laws, one being related to what can happen to certain printer cartridge products after being first sold within the United States, and the other is about patents on printer cartridges after being sold outside of the United States. Attorney and industry advocate Tricia Judge attended the oral arguments back on March 21st, 2017, and she joins me online. Tricia, this is almost a slam dunk deal, isn't it? Didn't most of the Supreme Court judges agree on this ruling?
This is such great news, David. This is the end of 20 years of fighting with Lexmark over the legality of the prebate program. It has now been decided by the highest court in this land. Patent rights are exhausted on the first sale of an item, period. So yes, and it was an almost unanimous decision. There was only one justice, and that was Justice Ginsburg, and she dissented only in part, and that was as to whether or not an item has patent rights still attached when it's first sold overseas.
So spell this out for me. What does overturning the Mallinckrodt law actually mean?
Mallinckrodt provided an estate for a patentee to use their patent rights to control an item downstream. As the Supreme Court in that case years ago held that as long as the patent holder clearly set forth the conditions that the patents must be used under, and in that case it involved medical supplies, and there was a health and safety issue, so that case was decided in favor of the patent holder. Now the Supreme Court has said Mallinckrodt doesn't apply. Basically, if the item is first sold here in the United States, so as not to confuse commerce and consumers, those patent rights are exhausted.
And what does this mean for the overturning of the Jazz Photo law?
Well, Jazz Photo provided basically in a footnote that it would that items first sold overseas had patent rights still attached, and therefore, if those items came back into the United States, the importers and the users could be sued for patent infringement. That has now changed. The Supreme Court says that patent rights are exhausted, just like copyrights were exhausted in the Kurtzsang case. Completely and utterly, even if first sold overseas. It basically rendered that in some, patent exhaustion is uniform and automatic. Once a patentee decides to sell, whether on its own or through a licensee, that sale exhausts its patent rights. Regardless of any post-sale restrictions the patentee purports to impose either directly or through a license. So, game over. You cannot attach restrictions using your patents.
Tricia, this must have huge implications for the cartridge aftermarket industry, not just in the US, but in Canada, Mexico, and especially in China, where so many aftermarket products are made these days.
It has global ramifications, David. This decision will change the way the United States aftermarket functions. Certainly it will be a boom for US remanufacturers who can now happily import empties from Canada and Mexico, which will also benefit those countries. The question about China remains to be answered because there are issues on both sides of the fence for the Chinese new-built products.
So this could be a hot topic for the Cancun Expo in just 3 weeks' time on June 22.
I am really looking forward to talking about this and discussing it with the audience. Absolutely, the Latin American aftermarket has a real opportunity here, and they should grab onto it because the marketplace in the U.S. has just now blown wide open. And the question of the Chinese new-built cartridges as competition is now huge. Whether or not you're better off using it and reselling a new-built comes directly into question. You wanted to do that when you knew you couldn't be sure of your cartridge stream and whether it was all first sold in the U.S. That question has now changed. So I look forward to discussing it with the audience and the other experts that will be there.
We'll see you there. Thanks, Tricia Judge. The two cases have been moving from court to court in the United States for some time now, the attorney who started it all being Ed O'Connor. Many thought he was crazy, as year after year he would appear at imaging events and speak confidently of overturning the Jazz Photo and Mallinckrodt laws. In my view, he has been like the legendary Captain Ahab on the obsessive quest of the great white whale, Moby Dick. And Ed O'Connor joins me online. Ed, just how long have you been chasing the demise of these laws?
It's been a while. It's been close to 10 years. The first time I got involved actively in dealing with the issues was when I represented Nine Star in the International Trade Commission, and charges were brought against Nine Star for importing into the United States products that they had previously purchased in other countries. And I just felt that Jazz Photo law, which was relatively recent at that time, was ridiculous and completely contrary to the laws of first sale extinguishment of patent rights, which I helped pioneer previously in the Court of Appeals for the Federal Circuit, which I did in the repeater type case. So that case, we lost that case in the International Trade Commission. We appealed it to the Federal Circuit, and the Federal Circuit upheld Jazz Photo. Then the Nine Star asked the Supreme Court to take that case, and the Supreme Court refused. Then, several years later, the present case came to my attention. It was a suit that was pending by Lexmark, would sued everybody they could think of for patent infringement for bringing in and imported products that had already been sold overseas. And so this is the same issue. It came to me by a referral. I took the case with the notion that I could attack Jazz Photo and Mallinckrodt in federal court and have another shot at overturning it. At that time, there had been an interceding between my previous representation and this one, a Supreme Court decision on copyright law, which I felt was right on point with what we were doing on Jazz Photo in this case. So we took that case to the Federal Circuit. The Federal Circuit had an en banc hearing in front of the entire circuit. We lost that. The Federal Circuit upheld its previous decisions in Mallinckrodt and Jazz Photo. So we went to the United States Supreme Court, which, as you know, just overturned both of those decisions. So it's been a long battle going on, like I said, some 10 years. I knew we would win this eventually because basically at the end of the day, the law is logical and fair, and it was logical and fair to overturn those two really bad previous decisions.
Okay, so why have you been so adamant that it's just not been fair?
Well, it's a fundamental principle. If you buy a patent, if I sell you a product that's patented, I relinquish my patent rights. You don't buy a product and then have to worry later I'm going to sue you for patent infringement. What had happened with Jazz Photo was they said, yes, that's the law, except unless you buy that product in another country. So if I have an automobile, I'm an automobile manufacturer. I'm not, but let's assume that I am for purposes of this discussion. So I own Ford Motor Company. I have patents on all kinds of parts in Ford Motor Company, thousands of them. So I sell this car all over the world. You go to Montreal, you're there on a business trip, you get a good deal on a Ford, and you pick it up, you buy it there, you drive it into the United States, and guess what? Under the Jazz Photo decision, you are now a patent infringer. You can be sued for patent infringement. If you sell that car to somebody, the person who buys it is a patent infringer. You can be held liable for suing a patented product. And yet it's yours. You bought it. You paid full value for it. I received full value for it. It makes no sense at all. It's completely fundamentally contrary to years of Supreme Court precedent going back into the early 1800s in this case, precedent of which I've been fully aware because it's my specialty. And so it just rankled me, and I saw people being really hurt by this, particularly, like I said, the Nine Star case, really hurt for doing absolutely nothing wrong. So I just determined, because law to me is not a business. It's a vocation, and an important one. And so one of the things I have as a lawyer, I have tremendous power. I have power of subpoena, power that nobody else in society has. And with that power, you can go after the biggest, most expensive people. It doesn't matter how rich they are, how many law firms they hire. We're all equal in the court of law. So I felt this was an opportunity for me, just one lawyer, to really do something to bring these big companies to heel, and we succeed.
Thanks, Ed O'Connor, and we'll see you in Cancun as well. And for all the details of these stories and other breaking news every day, go to our website at rtmworld.com. Thanks for keeping in touch. I'm David Gibbons.